stopped you without cause to stop you,
What?
was trying to, as she's trying to explain things to you, and that somehow or another that did what to you?
No, what I'm saying is that she was explaining her thoughts on, she was telling me what she was going to do, right? As far as the case. And I was stopping her to make sure I understood what she said, is what I was doing. She didn't appreciate me stopping her.
Or what she was telling you is, let me get through what I'm going to tell you, and then I can answer your question.
But I have a heart. I'm trying to follow her as she go along, sir. That's all.
That's what?
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Fletcher. Mr. Fletcher, could you please state your name for the court when you get up here?
Kobe Fletcher.
Judge, hoping for an adjournment to review discovery.
That objection, probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Bye. Let's call the case. People versus Edna Grima. Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Gurma. Your Honor, unfortunately, there's been a breakdown in the attorney-client relationship, and I have to ask to withdraw from representation.
Your name?
And the girl, may
What?
I be allowed to speak, Your Honor?
Go ahead.
Okay, Your Honor. I couldn't have. Okay. Excuse me.
Bless you.
Thank you. I couldn't have a regular, attorney from public defender because it was conflict of interest or whatever. So I
Right.
have from the county, right? Okay. Your Honor, my question is, if I request, if I ask the no probable cause to be handled right here, right?
If you ask for what?
If I ask her,
Okay.
okay, let's just put it like this. She and I were talking and I was stopping her to ask her questions,
Okay.
make sure I'm following her.
Okay.
And she didn't like that.
She didn't like what? That you asked a question?
Yes, sir. She said, if you stop me one more time while I'm talking, then I'm going to get up and leave. Your Honor, I'm 61 years old, okay? I have to ask the
So
question.
you're going to tell me that Ms. Steffen stopped you without cause to stop you,
What?
was trying to, as she's trying to explain things to you, and that somehow or another that did what to you?
No, what I'm saying is that she was explaining her thoughts on, she was telling me what she was going to do, right? As far as the case. And I was stopping her to make sure I understood what she said, is what I was doing. She didn't appreciate me stopping her.
Or what she was telling you is, let me get through what I'm going to tell you, and then I can answer your question.
But I have a heart. I'm trying to follow her as she go along, sir. That's all.
That's what?
I was just trying to follow her. I'm trying to follow her as she goes along, because by the time she gets to the end of what she's saying, I may not remember my question. So if you say after probable cause, if I ask after probable cause, then what's the next thing? See, first of all, I just want to say, I beg, I pray to God in Jesus' name, and I'm praying right now
Man, what do you want me to do?
I'm asking you to please forgive me, find grace and forgiveness for me breaking my bond thing, as well as I have a nonprofit youth organization. My nephew was killed in 2021.
Ma'am, right now,
Yeah.
your attorney has said there's been a breakdown in the attorney-client relationship.
I don't understand.
You don't understand that? So you don't, well, you got up there trying to be critical.
I kind of do
You kind of do what?
understand it because she and
Do
I.
you want Miss Stefan to represent you or not?
Do I want her to represent me? She don't want to.
I don't think Miss Stefan has ever turned anybody away. You need to listen to her, though.
What did she say?
So what did she say? To me?
Yeah.
She just
About-
said there's been a breakdown in the relationship, but I'm trying to understand that.
So now what? I'm just confused. I don't understand.
Maybe that's why when your attorney comes to talk to you and she stops you, she's trying to make sure to explain everything to you.
Okay.
Which means you have to listen.
Okay.
So what do you want me to do?
Forgive me for breaking my. Do I want her to be my attorney? Is what you?
Well, that's where we need to start.
Okay. Do you want to be my attorney? Do you think we can work it out?
Your Honor, with all due respect to the court and Ms. Gurma, I do feel bad about this, but I don't think that it's at this point fair to Ms. Gurma to have me continue to represent her because in my opinion, it got to such a point that I'm here now asking to withdraw. And Your Honor, I probably have. It's very rare, if ever. So Ms. Gurma deserves an attorney that she can effectively communicate with. I'm certainly willing to try, but I just don't think that's in her best interest at this time, Your Honor.
Yes.
So would you please forgive me for breaking the bond thing and please?
Ma'am, I'm not even dealing with the bond. I'm trying to make sure you have an attorney that you're going to listen to and can communicate with. But if Ms. Stefan is coming before this court, I don't think she's ever withdrawn a case before me and asking or believing that she cannot properly represent you. I'm going to take her at her word.
Okay.
So what I'm going to do is we'll need to have, I won't require a written motion, which I normally do to withdraw. I'll take the oral motion to withdraw. It's granted. Ma'am, what I'm going to do is, since I doubt the MAC office knew about it, I'm going to adjourn it out 1 week so that they can have time to appoint counsel to present you. So the probable cause conference will be adjourned to February 19th, 2026, 9 a.m. At this point, your bond was revoked. Your bond will continue as revoked until we can get through everything. So our bond will continue revoked. Thank you.
So I did submit one because I saw that the last report came in on 2/3 and I just wanted to.
On
make sure-
one,
On 2/3, that's when it was uploaded to my file for him. I just didn't see one in our file that had been given to the court. So I do apologize if there's been a second one received.
well, no, I don't think there's been a finding on competency at this point.
I think that we need to do that first and then.
Yeah, well,
Apologies.
that's what I'm saying.
Okay, I apologize.
So have you reviewed?
We have.
We
We
Any
stipulate to the
additional
findings.
evidence?
No additional evidence.
Any additional evidence of the people?
No.
The court would find that the defendant is competent to stand trial.
Thank you.
Court specifically would indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. So I'll need an order on competency.
I did submit one to the court, Your Honor.
You did?
I did.
And now what did you want to do?
I'm just asking for a 2-week adjournment.
That probable cause conference in this case then will be set for 26th, February 26th, 2026, 9 a.m. Or as your invite indicates, bond.
Thank you very much. We will be in touch.
Court calls case, people versus Samira San Paulo.
And on behalf of the people.
Roberto, on behalf of Ms. Dampolo, Samira, please unmute yourself, state your name for the record.
Samira Danpolo.
Thank you, Your Honor. At this time,
Thank you.
Thank you, Judge. At this time, discovery is complete. We are asking that the matter be set for preliminary exam.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Preliminary examination will be set.
Excuse me, I have a
February-
question. You know, I am in one court, important for me, but you know, I don't know. So,
Excuse me? Oh, that was not her. Okay. In the Danpollo matter, the matter will be set for preliminary examination February 24th, 2026, 9 a.m. before me. Bond will continue. Thank you.
You can log off, Samira. You're all set. Thank you, Judge.
thank you.
Court does call the case, people versus Ronald Fleming.
No, it's not me. No, soon.
Assistant Public Defender, I'll stand in today for Mr. Johnson, if Mr. Fleming allows, Your Honor. My understanding is Mr. Johnson's unavailable. My understanding is that he has communicated with the people. I'm sorry, step in for record, sir.
Ronald Fleming.
My understanding is that he's communicated with the people and with the court that he's requesting an adjournment on the file.
Who's requesting an adjournment?
Attorney Johnson, Kareem Johnson.
Oh, you're standing in. Do you have any objection to him standing in, sir? Pardon?
No, sir.
All right.
I can't hear anything.
Did he indicate how much of an adjournment or how long?
He said that he would communicate with the prosecutor and the court directly about a next date. I'm assuming he did not do that since you're looking at me.
I have not heard it.
So I would ask for 3 weeks, I guess.
I have no objection to 3 weeks. I don't have an exact date. And he called me with a.
March 5th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Let Mr. Fleming.
Thank you.
Take care.
I'll need a green sheet submitted on his behalf, Mr.
Yes, sir.
President. Court does call the case of the people versus Joseph Hodson.
Raymond Bush.
All 4 cases.
Thank you, Judge Cabral, on behalf of Mr. Hodson in the matter ending in 5232.
Assistant Public Defender Ben Dunn with Mr. Hudson. We have co-counsel Kyle Riedel.
I'm on Zoom, Mr. Denowith.
Okay, so where's your client?
Your Honor, this is a date and time set for a competent review hearing. Unfortunately, I've placed several phone calls to the number we have for Mr. Hodson, as well as emailed him without success. Mr. Brito, have you been able to contact our client?
I haven't either. I don't believe I have a good phone number for him.
So, Your Honor, given that the Forensic Center found him incompetent but restorable, we'd ask for an adjournment for 2 weeks so that we could attempt to contact him.
And I would join in that motion on my case as well.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. Those warrants will issue immediately on all these cases. Thank you.
Thank you, Judge.
Court calls the case, people versus Kurt Rushland.
Morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Bushline, who approaches. Your
Your
Honor,
name, sir?
Kurt James Bushline.
Your Honor, I believe we have a resolution in this case, but it's contingent on Mr. Bushline taking a plea up in Ithaca County. I believe that's set for March 16th.
Yeah, I guilty.
The sentencing date on the case in Gratiot County is March 16th,
And I misspoke, Gratiot County, Your Honor.
which is it. So we're asking to adjourn until after the sentencing date so that we can then.
So it isn't a plea, it's a sentencing.
Yes.
He entered a plea up there, Your Honor. He'll be sentenced on the 16th. The offer from the people was, the plea was after.
Probable cause will be adjourned March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Calls case, People versus Jaleesa Robinson.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Ms. Robinson, who should be on Zoom.
Ma'am, state your name.
Jaleesa Robinson.
Thank you.
Your Honor, we're discussing the negotiations. I believe there is a discussion of an amount of restitution. We're asking for an adjournment after March the 1st to see if my client can come up with those funds.
House conference, March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Matthew Kennedy.
And Assistant Public Defender, Shanazia Terry, Ruler, Your Honor, on behalf of Mr. Kennedy. Is it? I have.
One?
Yes.
Okay. And good morning. Go ahead.
PD's on a 22 matter.
Good morning, Your Honor. Please, the Honorable Court, David Burgess, on behalf of Mr. Kennedy, as it relates to the 26th matter.
Okay, what are we doing? You're asking for an adjournment.
We both are, Your Honor, so.
Probable cause conference, March 5th. Is he held on anything else other than these?
I don't, do you have another hold?
Just these two cases, right?
I think it's just
Just
these
these
two.
two cases, Your Honor.
Probable cause conference, February 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
And just for the court's information, I did see some out of county traffic holds.
Oh. Yeah,
Okay. Thank you.
I'll see you for next. All right.
Court calls the case, People versus Gary Coward.
Good morning, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Gary Coward. Your Honor, discovery is complete in this matter. We're requesting exam. Oh, thank you.
People have their witnesses available the 24th. Preliminary examination in person, February 24th, 2026, 9 a.m. Bond before Judge Barr. Bond will continue.
Thank you, Your Honor. All right.
Court does call the case, People versus William Matthews. Then let me try to get Ms. Potowski.
William, state your name. William Herman Matthews, Jr.
He's waiving.
Judge, yes, but before he waives, Your Honor, while this court has jurisdiction, I'm asking if his phone privileges can be restored. I'm not quite sure why it was nothing nefarious on his behalf, but we're asking that the court restores phone privileges. And then we're going to waive up to circuit court.
I didn't know.
Pardon?
Everything's turned off. I can't go to store. I can't do anything. Nobody's know why.
What are you saying this court revoked it?
It wasn't a court. It was somebody in the jail, I guess. I don't know. I've been trying to find out for 2 weeks. And they just keep saying it won't accept my.
Does the people's file reflect that I revoked it?
I reflect this is the first time it's even been in this court.
That's right. That's what I have. So I don't know where.
Something wrong with the jail, I guess. I don't know. Can you be of any assistance?
I could, but I won't because it's not my order.
The judge makes it clear that he cannot simply change a decision made by another court. But the hearing quickly moves to a more serious moment when the defendant chooses to waive his preliminary examination and move forward to circuit court. That decision could have a major impact on what happens next.
All right, I'll discuss it with the
Is he
jail.
gonna waive?
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
He will also waive the right.
Yes.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. Mr.
Judge, we acknowledge receipt of the information, waive its reading. My client would stand mute.
Defendant ever waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
February 26th at 1:30 with Judge Slay.
February 26, 2026, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bond will continue.
Thanks, Judge.
Thank you. Court does call the case People versus Abdul Latif.
Ready, Judge.
Good morning, Your Honor.
Still Feaster, Assistant Public Defender on behalf of Mr. Abdul Latif, who appears to be on Zoom. Please take your.
Sir, I'll need a camera and to state your name, please.
Good morning, Your Honor.
Thank you, Judge. We are requesting a brief adjournment to determine whether or not a motion is going to be
And
filed.
you'll explain to your client next time he's in court, so you shouldn't have his hand
Should I?
everything on.
Yes, Judge.
All right. I'll adjourn this matter. Probable cause will be adjourned to March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Judge.
Court calls the case People versus Theodore Enke, maybe.
Good morning, Your Honor. David Kennedy on behalf of the people. To carry out.
No, take your time. We're good.
I know, moving fast. Your Honor, on behalf of Mr.
Your name, sir?
Anthony. Judge, we need to, I put in a request for investigation, so we need to explore that a little further. That's why we're asking for an adjournment.
Is this the only thing holding him, or?
It is.
It is. Is 2 weeks going to be enough, given what you want to do, or you need 3?
Let's do 2 weeks for
2
starters,
weeks,
yes.
right. Probable cause conference, February 26, 2026, 9 a.m. Bound continue. Thank you.
Thank you.
Court recalls the case of People versus Margaret Pataski.
Joy Gaines, Assistant Public Defender, representing Ms. Petoskey. Thank you, Your Honor, for the moments to get everything in order.
Your name, ma'am? I need her unmuted. Ma'am, can you state your name?
Margaret Petoskey.
Thank you. I have a plea form before me that indicates that the defendant is going to be pleading no contest to the charge of use of methamphetamine, the 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Margaret Petoskey.
Okay, you can put your hand down. Ma'am, it is this court's understanding you're going to plead no contest to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
Two things about a no contest plea. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability.
Ma'am, to the charge of use of methamphetamine, how do you plead?
Guilty.
Really?
Oh, no
No
contest.
contest.
No contest. I mean,
Thank you.
I've been trying to get this over with since December 12th. I'm sorry. I'm having a little anxiety right now.
Okay. All right. You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You had signed or caused to be signed an advice of rights on your behalf?
Yes,
I hope so.
Well, did
Yeah.
you give your attorney permission to sign the advice of rights?
Yeah.
Okay, after going through that with her?
Yes.
All right. Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all those rights, including your trial rights, which are contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? No.
I was supposed to be released from MDOC on December 2nd, and this is holding me up. So I will be on
Gotcha.
parole once I get out.
All right, but you are not currently on parole.
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Michigan State Police report. I think was the number on there. Really? I don't need all this stuff. He's not gonna read it.
Correct.
Which one?
The last. Attorney Feaster, Assistant Public Defender on behalf of Brian Laster. Mr. Laster, how are you?
I'm fine, how are you?
Good. Please state your name for the record.
Brian Ian Laster.
Thank you, Judge. I did reach out to the prosecutor on this case. We are working on trying to get a resolution to this file. To date, we have not yet resolved it. Hopefully, we can come back in the near future and get this matter resolved. Be asking for a brief adjournment, Your Honor.
That's fine. Do you realize he has another case?
I did not, Your Honor.
Been rather sort of a cluster getting it here because we're not sure what happened, but we have a duplicate.
Oh.
It's a charge of larceny in a building, the 4-year felony.
Okay.
I'll give you the case number. It's 26F5 5030.
Okay. Thank you so much, Judge. I will include that in my I will include that in my discussions with the prosecutor.
I was told I was less than $200 in the charge I'm here for now. I'm not aware of what the charge is here for today.
Okay.
I was adjourned, I was
Okay.
and the $200 from a
Let's not
mill.
talk about the
Well,
facts of the case.
hold on, Mr. Laster.
And this stipulation charges are.
Mr. Laster, I'm going to ask you to be quiet. I don't want you to say anything about the case at this point. And certainly counsel doesn't know about that. I'm just going to, why don't we just go through the arraignment on this? Mr. Laster, the complaint alleges that on or about November 8th, 2025, location of 210 South First Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of larceny in a building. Specifically, it indicates that you did commit the crime of larceny in a bar or public house by stealing from the cash register drawer, and stealing from the cash register drawer cash, and then 3 bottles of High Noon seltzer, contrary to Michigan statutes. I'm not asking whether or not you did it or not, but do you understand what you were charged with?
Understand? Excuse me. Yes, I understand.
All right.
And,
that's a felony punishment by.
It's authority to.
Pardon?
The guy across the street.
Let's not talk details of the case today, because Anthony said he's finished.
All right.
So you understand what you're charged with,
Yes,
sir?
I do.
You understand that that's a felony punishable by up to 4 years incarceration
Yes, I
and a
do.
$5,000 fine plus court costs.
Yes, I do.
Do you wish to be represented by an attorney?
Yes.
Mr. Feaster, take over, please.
Thank you, Judge. Torture Feaster, Assistant Public Defender on behalf of Mr. Lester on the new file. Laster on the new file. Your Honor, we would waive any form of additional reading and we would stand mute, Your Honor.
Defendant, every way form of reading standing mute, court will enter not guilty plea. I will set probable cause in this case. How much time did you need on the other matters?
Just a couple of weeks, Judge. We had a fairly decent offer.
All right.
Maybe we can incorporate.
That's fine. I'll set a probable cause conference for February 26, 2026, 9 a.m. As to his bond in this case.
Your Honor, I believe he's had a bond in his other cases.
Pardon?
I believe he has a bond in his cases he's in for right now. I'd ask for a low bond on this one as well. He's getting credit on everything.
Well, what's he in on? I have 1,000 cash or surety on one of them, and one of them I'll say he has a personal recognizance bond.
Yes, that sounds right, Your Honor.
Pardon?
That sounds accurate.
What I'll do in this case, I'll set his bond. He's got other cases, so I can't do. I'll set it at 5,000, 10% at this point. Other standard conditions, including no assaultive behavior or possession of any weapons, you're not to possess any alcohol, recreational marijuana, or any illegal drug. I will also indicate that he is not to enter 210 South First Street in the city of Ann Arbor.
Thank you very much, Judge.
Thank you.
Thank you, Judge.
You're welcome. Court does call the case of the people versus Margaret Petoskey. Well, where's Miss Gaines? If I.
Oh, my God.
Ms. Gaines?
Pardon? Well, yes, because she's the one. Pass it briefly. Court does call the case of the people versus Jayla Allen. Jayla Allen.
Good morning, I'm Charlotte Stefan on behalf of Ms. Allen.
Morning, your name?
Jayla Allen.
Jayla.
It's okay.
All right.
Your Honor, I was just appointed last night to this, so I'm requesting an adjournment. Would 4 weeks be okay with the court?
Probably not, but you need 4 weeks.
Yes, Your Honor.
Hearing no objection, probable cause conference will be adjourned to March 12th, 2026, 9 a.m.
Thank you
Bond
very
in
much,
this
Your
matter
Honor.
will continue. Thank you. Court calls the case people versus Kadena Self.
On behalf of the people, Your Honor.
James back.
Good morning. Good
Morning, Your Honor. Christina Saxon from Myself. Please state your name for the court.
Kadina Self.
Thank you. What are we doing?
Your Honor, would like to make a bond argument and set this for preliminary exam.
Discovery is complete.
To my knowledge.
What date are we in? People have their witnesses available the 24th. Preliminary examination in person will be set February 24th, 2026, 9 a.m. before Judge Barr. As to bond.
For myself to be released on tether. Since the last time we were here, I've learned, excuse me, that the alleged victim in this case has been arrested and charged. When we were here last time, her arm was in a cast, and that was from a domestic violence event with him. They do not reside together, so I'm asking for a release with a tether. And in addition, just to show
Do you
that
think something has changed since the last time I denied bond?
I have more information about that, the fact that you only heard that there was a stabbing. From the looks of this, it actually warrants me having it looked at to make sure that he had not done that based on the angle of the marks. So, yeah, that has changed. It's a presumption that warrants more consideration. And on a side note, she wanted me to let you know she completed her GED for language arts yesterday. So she has used her time in here so far wisely.
Response.
Your Honor, I would object again at this time that previous case that was mentioned by Ms. Saxon was dismissed, I believe, 2 weeks ago. The facts that I brought to the court before I leave, I also put the issues out with intoxication as well. So at this point, I object.
Motion for bond reduction is denied. Bond will continue. Take a look at it again. Thank you. The court does call the case. People versus Kobe Fletcher.
This courtroom session showed how quickly a hearing can shift from routine scheduling to serious decisions about bond, legal representation, and a defendant's future. Some defendants received more time, while others faced strict conditions or remained behind bars. In the end, the question remains, how much should personal progress influence the consequences of a pending case?